The next speaker will be Chamara, Sampath, Kodikara. Chamara is an undergraduate in faculty of law at Sri Lankan Criminal Justice. Title of the presentation is The Crisis of Low Conviction Rates in the Sri Lankan Criminal Justice System. Is it an inherited sign of adversarial method of litigation?
Good morning, Chairperson, and good morning, dear ladies and gentlemen. My research topic is relevant to the crisis of low conviction rate in Sri Lankan Criminal Justice System, a critical analysis of root causes. Before going to the details of the research, let me introduce some critical words of this topic. The conviction rate. Generally, the conviction rate is the percentage of ratio of numbers of conviction out of the number of criminal cases brought in a particular jurisdiction, specific time, would show the degree of efficiency and effectiveness of such criminal justice system. And this is my outline of my presentation. As a common law country, Sri Lanka exercises adversarial method of litigation. Where the prosecutor is at the center of the stage of a criminal trial and plays a leading role while the judge switches to more neutral mode compared to the adversarial method. Our criminal justice system merely based on Criminal Procedure Code of 1979 and Judicature Act 1978, Police Ordinance, Bail Act of 1997 and the other relevant substantive laws including the Penal Code. Though it reveals with the research that a problem of low conviction rate arises due to the procedural facts rather than shortage of substantive laws at the conclusion of the research. And let me give an insight how derive this particular issue of conviction rate. When we come, for instance, when we analyze the disposal of reported grave crimes in 2012, according to the official statistics of police department, which was publicly available, or only the amount from the complaint only the 25% of the police were claimed and 25% of cases accused unknown, and the most significant thing is 48% of cases still pending under police investigation. So let me give a more elaborate on this particular part of the 25% of plain file. What happened to this? Right. This will give how the problem derived. Right. See that the majority of 65% of actually 66% of cases were pending at the magistrate courts, and 91%, just 1% pending at the high courts, and among from the claim filed that 23% of 23% of cases convicted already and acquitted only 0.78%. But the thing is, the most people argue that the conviction rate of Sri Lanka is very low. But if we say our conviction rate is very low, in another hand we can say that then the majority of the accused should be released. But see that only 0.78% accused were acquitted. See that problem exists. You can see from the yellow color, at least 65%, 66% of cases still pending in the magistrate courts and in the high courts. So, and this is not only these trends prevail throughout the history of the Sri Lankan judiciary. When you compare the last few years from 2007 to 2012, you can see that the gravity of the problem that majority, the large portion is still pending in the police, under police investigation, and another portion, a significant portion, is still pending at the magistrate courts. So this is the methodology which I implemented, primarily based on the statutes, case laws, textbooks, databases and journals, and expert views, and I do some sort of field visits to visit police stations and magistrate courts to fact-finding mission. And when we compare, I think you people are very clear about where the problem exists. Majority of the file cases are still pending in the magistrate courts. So, the crisis will exist with the criminal procedure or the judicial system. Even though we have sufficient or the sophisticated legal regime, that practically how it implement is a matter solved. So, the issues of access, I want to give you some insight where the problem exists. The matter of the criminal investigation, the role of magistrate. Actually, let me cite the somewhat old case, Emperor versus Nazir Ahmed in 1944. Lord Porter specifically mentioned about the role of the magistrate. The function of judiciary and the police are complementary, not overlapping. And the combination of individual liability with the due observances and law and order is only to be obtained by leaving each to exercise its own function. And section 124 of the Criminal Procedure Code also mentions the same thing, that how the magistrate works, the responsibility of the magistrate, and what is the demarcation between the work of magistrate and the police. Actually, according to our criminal procedure law, magistrate is the chief investigation officer. But he only needs to assist the police investigation. So, the role of magistrate is vital when we regarding the conviction rate. And the lack of knowledge and efficiency with the investigation officer, poor coordination among the different agencies such as government analysts, and the insufficient manpower. I found out that there's a critical issue with the manpower of the police and the lack of motivation within the police force. And in my recommendations, I strongly believe that that rather than the independent police or the independent judiciary, it is necessary, yes, but rather than independence, we should recommend checks and balances among the institutions. Even though we give independence to judiciary, who is going to monitor the outcome of such institutions? The checks and balances is the best way to eliminate such problems, especially this conviction rate. Because even though most people say we have very low conviction rate, there are no any mechanism to find out, even though there is no any proper statistics to find out where the problem actually exists. Even in European countries, there are standard statistics institutions to give such statistics, but in Sri Lanka we haven't such an institution. And Attorney General Department duties, in current context, Attorney General Department duties are centralized. But I recommend, with the findings of my research, that the functions of the Attorney General Department should decentralize. For instance, let's just say, there's a possibility to Attorney General Department to appoint at least the senior counsel, one senior counsel to each district, and he can assist and he can overlook the functions, how the police investigation are conducted. There were huge number of cases forwarded by police department to the Attorney General Department for legal assistance. Huge number of files, but due to this inefficiency, all the cases are struck. So, if we decentralize this function from the district basis, so that particular senior counsel can assist the police and do a better job. And further, I recommend that the relationship between police and Attorney General Department should strengthen further. And if Attorney General Department has we amend the laws and give provisions to Attorney General Department to appoint not a senior counsel but a counsel to each police station to work, then the several human rights issues will never come, because the lack of training of the police can be overcome by the competence of the lawyers who knows about human rights and criminal law as well. So I recommend that each police station can consider to the employment of a counsel from the Attorney General Department. And next, as a conclusion, I recommend the Judiciary Act number 2 of 1978 together with the section 145 of the Criminal Procedure Code should be amended in order to afford the Attorney General's discretion to file a direct indictment in appropriate cases at any time. And magistrate should be encouraged to institute legal proceedings in homicide and cases immediately after the conclusion of the inquest. And lastly, I strongly believe that the criminal trends are different and highly dynamic. That modern criminal activities are done within the cyber world, electronic malpractices. So the police and the attorneys should be acknowledged with this latest knowledge, and with that we can have a better conviction rate in future of this kind. Thank you.